When we talk today, we're basically going to go over the offer to purchase in this week and next Monday. So it's, it's 10 pages long. It takes a while. I'm not going to explain line by line, but what I'm going to do is present it as if you would present it to a buyer. So if you haven't written an offer to purchase at this point, or you have, but you haven't written one in a while, or you just would like another perspective on it, I'm going to go through this offer to purchase as if I were presenting it to a buyer. So it's sort of my way of sitting down with a buyer and how I go over it. One of the things that I've always done in the past when I had a buyer, especially a first-time home buyer, was give them a copy of residential offer to purchase. Hopefully that's what they were doing, or condo, whatever they were looking for, and give it to them early in our home search so that they can take home and go over it. I told them, to read it over. I said, don't read it while you're going to bed because it'll put you to sleep. But read it at some time before we actually find a house, so that when we do sit down to write the offer to purchase, you do have some kind of a familiarity with it. But there's a lot of presentation to the buyer when they're writing it. And one thing you want to avoid is spending a long time presenting the offer to purchase to the buyer. As I said, being 8 pages, every line is full of something really important. And you don't want, for the very first time, to be explaining all these lines to your buyer at the time that you're actually trying to get an offer out and over to a listing agent. So use the time during showings to get them familiar with it, talk about different parts of the offer. But when you sit down, try to do it in a timely fashion. Don't turn it into a 3-hour offer writing session, because there's a lot of anxiety at this point in time, and you don't want to add to it by just making this a real ordeal. So what I'm going to do today is go over the offer to purchase in the attitude that I'm explaining it to a buyer. I'm not going to fill it in. What I would ask all of you to do who are on the call, if you'd like, is to go into zip form when we're done sometime this week, or wait till part 2 of next Monday. But go into zip form, pull up a blank offer to purchase, put it as a test offer, and write me an offer, or Steph, write us an offer to purchase as if you were practicing one. Get it sent on DocuSign to us, and then we can discuss how your offer was written. But the actual writing an offer, I think, is very good practice, and you don't want to practice on a real buyer. So practice on us, write up an offer to purchase, send it to us. We'll give it a good critique, give you some suggestions, pick a house out of MLS, doesn't matter, and draft a nice, strong, competitive offer. Okay, so here we'll go. All right. My buyer and the very first line is talking about the agency. Now, if I have buyer agency with you, which I know most of you are practicing buyer agency, that's this very important line 1 or 2. I'll tell you that most new licensees, when they send me an offer to review, they've forgotten lines 1 and 2. So it is important to establish the agency right off the bat. So first line, drafting the offer on, you put the date that you're drafting the offer, and then you strike out the ones, forms of agency that you're not. So if you are a buyer's agent, you strike off agent of seller listing firm, and you strike out agent of buyer and seller. If you do not have buyer agency, they're customers, then you strike out agent of buyer and agent of buyer and seller. The only time you would leave agent of buyer and seller is when you have multiple representation and you are representing the seller and you have buyer agency with the buyer. And we really try to discourage that form of agency. That's called dual agency. So remember those first lines, 1, 2, don't forget them. They're important, and you really have to communicate to the listing agent who you are. So now the next point we're going to put down is put down your name, and I need your full legal name. Middle name or middle initial is important in this, especially if you have a common name. And we offer to purchase the property, and this is where we put the address of the property we're going to write on. And make sure that we also talk about where it is. It's in the city or village of whatever. And in the county of Ozaukee, Milwaukee, Washington, whatever, in Wisconsin. If you're doing vacant land and if you're doing condominiums, make sure that you're talking about the full description of the property, the building, the address, and whatever. The next part you're putting in is purchase price, and you're writing it out in verbiage on the first line, and then you put the numerical version of it in the smaller line. So write it out very carefully. A lot of times it's a good place here to put it in block print or some kind of very readable. Most of us now are doing everything in zip form, and make sure that you have the lines filled out correctly in zip form. Included in the purchase price, and this is a time we're going to go back into MLS, double check what it says in MLS of what is included in this property. Let's see if there's the appliances are included or whatever. And then we're also going to read what's not included. It's best to fill out our offer based on the instructions from the listing agent of what's included and what's not included. I don't think you want to include anything that's not listed there. If you do, we'll put it in and see how it goes. But those are lines. Remember what is included. It's all fixtures of the property, so you don't have to add those. And fixtures mean something that's really attached to the house, either a screw, nail, attached and fixed to the house. And if you have any confusion about it, they describe what a fixture is and give examples of it here in the contract. So we'll go over those to make sure. And not included is anything that's seller's property or some things that aren't fixed on, something that's easily removable, like a very fancy mirror that's just hung on a nail. The mirror isn't screwed to the wall, just the nail is. So these identified fixtures, as they say here in lines 24 through 36, give you some examples of what fixtures are. And it even goes out into the garden, what's on the roof, and things like that. So if you're talking about fixtures versus what's included, make sure that we read this carefully and we go over it to be clear on what we're adding and what we're excluding. You can exclude something that is a fixture. Say you don't want it, which means you're saying to the seller, get that out of here before I buy it. Things like playground equipment and stuff like that. Exclude any fixtures. Now, I'm going to stop and read it, the lines where it's talking that it's in bold or it says caution up front, because those are the areas that you want to make sure that your buyer or my buyer here understands. So the caution here, exclude any fixtures to be retained by seller or which are rented, like water softeners or water treatment systems, LP tanks. So in that section, make sure that the seller, and you can double check with the listing agent, we'll double check with the listing agent to make sure that that water softener isn't rented or is rented. The next part is binding acceptance. So we're going to say we want to reply to this offer exactly the way it's written and accepted by this date. And usually we'll give them a little time, depending on the type of market it is or the competition. I'd say let's give them 24 hours to respond to this. If it's really tight market, we'll find out, we'll want a response sooner than it. But remember, if they're going to counter this offer, this date on time and date on line 40 doesn't mean anything. This is only if they are accepting our offer as written. So, and here we have a caution on line 42. This offer may be withdrawn prior to delivery of the accepted offer. Steph and I get these calls quite a bit. The buyer has changed his mind and the offer's been sent off, but it hasn't been accepted by the seller at this point. What can I do? What can I do? Well, if you make sure that you verbally and then follow it up with something in writing that you are withdrawing your offer before the seller responds. It's really important. So if you have any buyer's remorse, tell me now, please, before we send this offer off. Let's talk about all the ramifications of this money that you're spending, of this house that you're buying, but we don't want to get into a last minute buyer's remorse. So get that all out of your system now. Acceptance occurs when all buyers and sellers have signed one copy of the offer, but separate by identical copies. That isn't so much an issue anymore when we're using electronic contracts, but just remember, if they're identical and they're signed separately, that is official. But cautions, deadline in the offer are commonly calculated from acceptance. And we have a lot of questions about this too. When do we start counting the days? Start on the first next day is day number 1. So deadlines in the offer commonly calculated from the date of acceptance. Consider where the short-term deadlines running from acceptance provide adequate time for both binding acceptance and performance. So we'll make sure that we give them enough time to accept this, but we want to make sure that we have time to have it binding and what we're going to be doing about it. Line 47, let's put down the date you think you want to close. Give it some time. The mortgage is going to have to take some time. Title's going to have to take some time to get the property prepared. So we can't do it like tomorrow, but what is the best time for you to close? Let's make sure that it does, the date that you choose doesn't fall on a weekend because most title companies aren't open on weekends, and usually about 35, 45 days, pretty standard. Steph, jump in here anytime you have some comments too, please.
I will.
So that's where the closing date goes. And as you notice now in the new form of the offer, it's put right up on the first page because it's important. So they're giving you a caution here to a buyer about the risk of wire transfer fraud. It's becoming more prevalent, and we want to make sure that any wire instructions that you get should be independently verified by phone. So if someone calls you and says, here are your wiring instructions, you're to deliver it to such and such, make sure that you do a verified phone call for that before you receive some instructions and follow up on it. So get a verified phone with the person in the title company, the banker or entity. The real estate licensees in this transaction are not responsible for the transmission or forwarding of any wiring or money transfer. Fraudulent wire instructions are happening. They'll call your buyer and ask for or give them the instructions, and what they're doing is sending that money right off to somebody that is not entitled to have it. So this is important, and remember the phrase verified by phone or in person of those wiring instructions. So now on page 2, we're talking about the earnest money. So what kind of earnest money do you want to put down? The earnest money really means earnest, that you are going to go through with closing, that you're going to put enough down that will prevent you from having buyer's remorse in the middle of it, or deciding you just don't want to do this, or you don't like something, but your contingencies are all gone, and you would risk losing this money. So $1,000 may not be worth risking at this point, but if you put down something more, the seller is going to look at it and say, they look like they're really in earnest about this offer. So put down something that is verifiable, worthy. And then you put down how much you're going to put in. Generally in our market, we don't accompany our offer with the earnest money, but we wait until maybe 3 days, 5 days, it says in the contract, after you've had acceptance. And then that's when your earnest money is going to be due. And when you do have it, you can put it through trust funds in MLS, or you can deliver it. You, the buyer, can deliver it personally to the listing office, and the check will be made out to the trust fund of that company. So if we're buying a listing made by presented by Shore West, the earnest money check would be made out to Shore West trust account and then delivered over to one of the Shore West offices. So in that, you have a choice on line 60 to determine whether it's going to be the listing firm or drafting firm. Really scratch the drafting firm. It's pretty, it's much more efficient to deliver it to the listing firm. And 5 days if left blank or whatever.
I do think that we're encouraged. I mean, I know we're encouraging.
If a firm does not hold the earnest money, an escrow agreement should be drafted by the parties or attorney, as lines 67 to 87 do not apply. If someone other than the buyer pays the earnest money, consider a special disbursement agreement. A long time ago, not a long time ago, 5 years ago, I sold my son a house, and I thought, well, I'm a real estate agent. I thought I'd do him a favor and I'd drop off an earnest money check to the listing firm for him because he couldn't get to the bank. The listing agent, who I knew very well, said, Joan, what are you doing? You can't write a check for your son for his earnest money. So make sure that you have the money, can write the check, and you can get it over to the listing firm or through trust funds in time. And then they talk about here the disbursement if the earnest money is held by a firm. It's just dispersed back at the closing table. It becomes part of your money that you bring to closing. In the section 78 to 87, they're talking about the legal rights of the action that the firm's disbursement has and does not have. So if there happens to be any kind of dispute over who gets the earnest money, if this does not follow through, this is giving the firm harmless of any liability. They are not the controller of the earnest money. They don't decide who the earnest money goes to. It has to be decided by a court. So that's just explaining the firm's role in holding, the listing firm's role in holding the earnest money. And basically, if there is a dispute about earnest money, the best place to handle it is in small claims court. It doesn't matter how much the earnest money is in small claims. For earnest money, it can be any amount. And a judge just sits there with both parties, listens to the situation, and decides who gets the earnest money. It costs about $200 or $500 to go to small claims court, much better than going into hiring an attorney and going into court. So we get to the next part, and a lot of people just read over this part. Time is of the essence, but this is the heart of a contract, is time. And the dates in the contract are exceedingly important. And that's why it means it's of essence. It's of the essence. It's important. And generally we don't strike anything in these lines 88 to 91 because we want every date in this contract to be of the essence or extremely important. So you're going to go through this contract, making sure that we have the dates and times that we agree to so that the seller understands where we're coming from. The next section is about the real estate condition report. This, hopefully at this point, we have the real estate condition report, and we do. We got it out of MLS and we've reviewed it. And all of the signature on that is just to acknowledge the fact that you've received it. Doesn't mean that you totally agree with it, but you've received it. So it's an acknowledgement of receipt. But this is a Wisconsin law. It's not a real estate law. It's not a Keller Williams law. It is a Wisconsin law that all owners of property fill out a real estate condition report, whether they're for sale by owners or going through a listing company. And the important thing in this line is rescission. If you don't get this condition report, which we do have, but if we didn't get it, you can actually, no later than 10 days after acceptance, you have a rescission right that you can actually back out of the deal if you haven't received a property condition report. Sometimes the seller will refuse to fill out a condition report. If they do that, they have to fill out a form, and that has to be given to us that they've actually refused to sign it. Or they may have an exception to filling out the condition report, when say it's in an estate or run by some kind of deed estate and not part of the actual seller. So the condition report describes all the defects that the seller is actually aware of, and it becomes a very important document when we review the house, especially after we see the inspection report done by your inspector. It'll agree, or some things may be new to the seller that he didn't realize. The property condition representations represents to the buyer that as of this date of acceptance, seller has no notice or knowledge of conditions affecting the property. These lines 112 through 177. Again, because this is part of the offer that really doesn't have much filling in, agents sometimes or buyers sometimes seem to gloss over these. But this is these representations are a very important part in our offer that we're drafting. So it's saying that other than those identified in the condition report, which was received by the buyer prior to the buyer signing this offer, is made a part of the reference. So insert conditions not already included in the condition report, if you know of any. But starting with lines 1 through 112 down to 177, I think it is, yes. These are representations that when a seller accepts our offer, they are agreeing that these are representations in the house. And as I say, it's important to review these lines. It's important to understand what the seller is saying. Yes, we're representing this. Say, take line 164, no legal access to the property boundary. Well, there's a driveway off a road, so there's legal access. And some of these appear very cursory, but they're really important representations that the seller is saying, these are conditions representing my house. So don't ignore these. This is a section that maybe your buyer, before you write an offer, can review as they're looking at homes and making sure that these representations are in the house that they are going to be writing an offer on. So other than these defects or lack of representations or the condition report from the seller, now it's our turn to also now find out about the house from our point of view, which is now we're going to have an inspector come in, independent inspector, licensed in the state of Wisconsin. Sorry, it can't be a family member who has experience. It really has to be licensed, certified inspector in the state of Wisconsin. And we're going to hire him, you're going to hire him to come through the house and do a full top to bottom inspection on the property. And it takes a while. I would like you to be present at the inspection. I'll be with you at the inspection and we'll be there with the inspector. Plan on taking about 3 to 4 hours, sometimes depending on the size of the house, but it's generally about 3 to 4 hours inspection. It'll teach you a lot of things about your house. It just isn't something to go find what's wrong. Most good inspectors will talk about maintenance and how to maintain the properties in the house that they see. So what you want to do is, this is going to be, it talks about the difference between testing and inspection. Testing is a completely different part of this offer than the inspections. And this contract wants to make sure that they are separated. You want an inspection and you can sign up that for the inspection, and all of that an inspector will be able to see, disregarding the fact he doesn't have x-ray eyes. And that's separate from testing, which is actually taking samples of things, sending it to a lab, getting the results. So they separate these as much as they can so that you're not confusing a testing to be part of inspecting. So they explain this very carefully. And in the bold language on 186, any contingency authorizing inspection should specify the areas of the property to be tested. So this is a big mistake a lot of agents sometimes make. They just say all testing. They don't specify exactly what tests, or they say something like any tests recommended by the inspector. No, if we decide to put in tests, we'll specify exactly what needs to be tested. So buyer, and then you're wanting to make sure that you have access to these properties in this contingency, and that you're being able to make sure that the property is put back together, restored back together after any testing or inspection. So they give you this sort of lead up and try to explain the difference between inspections and testing so that we understand, do I want to do testing as well as inspections? But don't lump them together. So the first contingency comes up, and it's an inspection contingency. In the past, a lot of agents just put on line 197 entire premises. No, you don't need to do that, because it says this contingency authorizes only inspections of performing a home inspection of the property on line 1 that discloses no defects. That's what the inspection is about. It's further contingent on a qualified independent inspector. So he's already talking about inspecting the entire premises. Now on this line, it's further contingent on an independent inspector or an independent qualified third party performing an inspection of. And for this line, you don't put entire premises. We're going to put exactly maybe something that we're concerned about. And when we were looking at the house, we saw that there were some ripples in the roof shingles. We'll put on this line that we want a separate inspection of the roof. Or maybe we saw some cracks in the basement wall. We would put foundation. It just means that we may want a separate inspector who's qualified in this area to come in and look at the roof, or come in and look at a foundation, or things like that. So that's what these lines 197 and 198 are for. And when we looked at this house that we're going to write an offer on, we were a little concerned about the chimney. It had a little bit of missing mortar from what we could see from the front yard. So maybe we'll put down chimney here. we will want a separate inspection of the chimney. And if there's anything else you can think of that you would like to have the rights to have a separate inspection, we'll put those in that line too. Buyer may have follow-up inspections recommended in a written report resulting from an authorized inspection. That means the inspector that you hire, if he puts in an area that he's a little concerned about and he recommends somebody to come in and look at that who's more experienced in that, you automatically have the right to have an inspector, a separate inspector, come in and look at those areas. Provided that they occur prior to the deadline, inspections shall be performed by a qualified independent inspector or independent third party. So this sort of describes what our inspection is going to be about and the limits of what our inspection is. This caution that we want to make sure that we should provide sufficient time. So it talks about how long are we going to give for our inspection contingency. And obviously sellers want a short time because they want this part over with as soon as possible. And the you want as much time as you can get. So a good compromise in the middle, mostly they say 15 if left blank, 10 to 15 is probably the most common. But what this caution is saying, provide sufficient time to have the inspection, to schedule it, go through the inspection, get the report, any extra inspections that may be recommended or that you are looking for, and then have time to negotiate. There are defects found, you want to be able to negotiate them first with the seller. And then if it doesn't negotiate, we want to be able to talk about what your next step is. But all of that has to be done in this line right here, the number of days that we put in for this inspection time. So 15 is what they suggest, actually. We are going to deliver to the seller a copy of the written inspection report right away, and as soon as possible, let him look at it. And a written notice if there are any on any defects that we find. We're going to talk about those in an amendment first. An amendment is where we do our negotiating. So a proposed amendment is not a notice of defects and will not satisfy this notice requirement. So we're not going to file a notice of defect if we've found some defects until we could go to the amendment and negotiate it. Remember, a notice is just a one-way shot and the amendment is back and forth until we get to some agreement. So that's what this caution is about. It says, for the purposes of this contingency, now this is an important little sneaky line in here. 210. For the purposes of this contingency, defects do not include structural, mechanical, or other conditions, the nature and extent of which buyer had actual knowledge or written notice before signing this offer. If this stays the way it is in our offer, it means that when it gets to the point of writing down defects, you can't write down a defect that you already knew about. One, say, that was in the condition report, or one that the seller disclosed to you before we wrote the offer, or one that was very obvious that we saw before writing the offer. So the nature and extent of which is a phrase for the courtroom to decide, but it just means here that you cannot list a defect that was already knowledge given to you before you wrote the offer. Now, some agents will cross this line out, and that means that they have we're going to have the inspection, and then if defects are found, we can list those defects, plus we can list the defects that were listed in the condition report too. But it becomes it's legal to do it if this line is crossed out. If the line is not crossed out, then you cannot list defects that you were made aware of ahead of time. So as long as we understand that, we can decide whether we're going to cross this out and have the ability to list all the defects or not. Now, this is important. No, defect is defined on lines 445 and 447. They'll give you the actual legal definition of a defect. Means a condition that would have a significant adverse effect on the value of the property, would significantly impair the health or safety of future occupants of the property, or if not repaired, removed, or replaced, would significantly shorten or adversely affect the normal expected life of the premises. Now that is as vague as fog, and it's meant to be that way because it actually becomes a legal decision. So using that vague description of what a defect is, health or safety, having an adverse effect on the value of the house or the property, or if not fixed, would affect the life expectancy of the premises. Those are the three general requirements of what a defect is. Now, our life's been made a lot simpler with a new law passed in the state of Wisconsin for our inspectors. Now, when we hire an inspector, the inspector has to identify what he considers a defect, and he's using these definitions of a defect. He will summarize in his inspections and list it under defects. So he actually selects what he considers a defect. And then we can use those defects in our notice of defect if we're going to send one, because it is part of the inspection report, which we've sent to the seller. So this is important to decide what we get to in that point. If we get to a notice of defect situation, this is all part of this very important contingency that buyers should have. In our competitive market this last year, a lot of us were foregoing the inspection contingency to make our offers look better to the seller, but it is a very high risk to do so because it can end up costing you, the new buyer, thousands and thousands of dollars that remain undiscovered. So now this part about right to cure, I want to explain to you what right to cure means. You have a choice of scratching out one of these. Either seller shall have the right to cure the defects or seller shall not have the right to cure the defects. Let me explain what this means. If we find out there are some defects in our inspection report and we send an amendment, because that's how we negotiate, we send an amendment to the seller and say, fix this, fix this, fix this, whether they're defects or not. We want this straightened out, we want these, removed, and we want this defect cured or whatever. But that's all in the amendment part of negotiating. But say the seller refuses to do anything, now we're still within this time period of the 15 days or whatever. Now we have to send the notice of defect, and that's on a notice to the offer to purchase. And it starts out, you write on that notice, this is a notice of defects. So now we're slamming the door down and saying, okay, this is decision time. We're sending you a notice of defect, and it depends on right here whether the seller can cure those defects once he gets the notice, or he has no right to cure the defects once he gets the notice. And if that's the case, the offer is dead and earnest money returned to the buyer. But if we're going to give the seller the right to cure the defects, that means we send him the defects. He has 10 days, if we leave it blank, to decide whether he's going to cure our defects or not. He has to cure the defects in a good and workmanlike manner. And then he has to deliver to the buyer a written report detailing the work done no later than 3 days prior to closing. he has to cure all of the defects that we've listed in this notice of defect. He can't say, well, I'll cure this one, but I won't cure that one. It's all or nothing. He's got 10 days to decide, and then send us a notice saying he's going to cure, and then delivering to us a written report detailing the work. If that doesn't happen, this offer shall be null and void if the buyer makes a timely deliver of the notice of defects and the written inspection report, and then the seller does not have the right to cure. So that's part of what we can choose here. Or the seller does have the right to cure, but says he's not going to do it. And he sends a notice saying, I'm not going to cure that. In that case, this offer shall be null and void. Or if the seller just ignores us, and this has been a question lately I've received, he doesn't timely deliver the written notice that he's going to cure in that, but if it goes past these 10 days, the offer is null and void. So this part right here, I hope you understand it. I hope you as a buyer understand this, because this will affect what we're going to do in case some defects show up in the inspection that you may not want to live with. So that's where we're going to make this choice. Are we going to give him the right to cure, or are we not going to give them the right to cure? Obviously, if we're going to be in competition, the seller will want the right to cure.
Can you guys hear me
Now,
okay?
they're putting in one testing contingency separate. It's not part of the other testing contingency block, but because this is the most popular, most common test that is done, and test means taking a sample, they gave it its own contingency block. So it has to be less than 4 picocuries when a radon test is put in. A radon test cannot be put in if this is not filled out. So if this is checked, that means whoever is doing the radon inspection, and sometimes it's the inspector, has the right to put those in. If they've checked this, the radon test will be put in, and then when it is reviewed, when it's finished, it has to be less than 4 picocuries. Usually the buyer pays for this. And if it's within 20 days, if this offer is deemed satisfied, unless the buyer within 20 days of delivers to the seller a written copy that the radon of 4 picocuries, that it was a radon of 4 picocuries and higher. So it's okay if it's less than 4 picocuries, and this has been a dispute happening many times. It is at a defect level if it is 4 picocuries or higher, and a written notice objecting to the radon level. Now, we can give the seller the right to cure this or not cure it. So if the 4 picocuries or more and he does not have the right to cure, offers null and void. But if we give him the right to cure, if the radon comes in 4 picocuries or more, he can go through the same process with right to cure. He can send a notice saying he'll cure the radon. He can install a radon mitigation system, and then it be tested that it's under 4 picocuries after it's put in. But it's null and void if the seller says, either the seller doesn't have the right, or the seller says, I'm not going to fix the radon. Now, to me, and let's just look at this whole block on radon testing. The way I like to describe it to my sellers is to cure radon in a house is very easy. It's usually about $1,000. It just vents the air that's in the lower level up through the sump pump area and out to the outside. When a test is taken after a radon mitigation system is put in, it's usually, well, it's always below 4 picocuries. It's usually 1 or 0 or whatever. I mean, it literally gets rid of the radon gas in the house. A radon test in this contingency is usually a little 3 3-day cardboard test to detect at that moment in time what the radon level is. And depending on a lot of environmental factors, radon levels go up and down in a house all the time. You know, as I said, environmental factors. So to really accurately know what the radon level in a house is to do a seasonal radon test. Generally over a year, you put it in like once a season and see how it fluctuates. There are also shorter ways. You can put in like a 2-week review of what the radon level's in and watch them go up and down, and then they take the average. The point is, I think to make a radon inspection, a radon test contingent in a property, if you really want it, is not worth the risk. I think the risk is easily taken up by a buyer to have a real radon test done to find out what the real radon level, especially if you're really going to be using the lower level. You have a finished basement, kids are going to be down there. Then you really do want a real radon test, not just this point in time one done during inspections. And then if you decide, you find out you have this long average of high radon, then spend $1,000 in the house now that you own and get rid of the radon. And it does. To me, the mitigation is good. The cost is reasonable. And I don't think it's worth putting in as a contingency in your offer. But that's my way of explaining it to you, the buyer. It's certainly up to you whether you want to include it or not.
Agreed.
Any comments about that, or any comments about the inspection contingency at this point?
Joni, I was, and I
parts of our offer.
Joni, I did throw this in the chat, but
oh, you're good. Unmute yourself if you have a question and throw it out there. Or put something in the chat. Okay, if you're good to go, and as I said, these really are important sections of our offer, and we want to make sure that our buyer understands them and knows what he's signing, which is the important part. So now we get to the second most important part of an offer. This contingency is the financing contingency. And if you're fortunate enough to have the total amount of money in some kind of an account, as a buyer, you can write a cash offer. And it's just up to your financial ability, whether you can write cash, you'll be able to get a hold of the money and give that cash check at closing to the seller. But most of us, and most of your buyers, most of all of us who are buying a house would like to take out a financing contingency on this. They want to put a mortgage loan on the house, and they want to pay installments in a mortgage payments. And so that's what is why it's a contingency. Make sure that we can get that loan from the lender. If we don't get the loan, we are not obligated to buy the house. We'll get our earnest money back. We'll be able to move on and find something else, or save up a little longer and put more down or whatever, get our finances in order. But this financing commitment contingency is very protective of your buyer. And if you're a buyer's agent, as I am, I'm going to want to make sure that I protect my buyer and not get him into a situation where he's sitting at a closing table and he's trying to call his rich Aunt Edna for a loan and get the money because he's obligated to buy this house. So finance contingencies are important in our competitive world. In 2021, lots of buyers were foregoing their financing, and they were going to get the money all pulled together for closing, and so they wrote cash offers. But there can be a lot of risks in that, and you know, things happen, and things usually happen when they happen in real estate. So you've got to be prepared for that. So to write this, what you really should have is some kind of mortgage calculator. There's one on MLS. You should have one on an app in your phone. But you want to be able to quickly fill in the lines here with the money that they're going to be borrowing and what that rate is going to be according to what their lender has recently quoted, and then what their monthly payments are going to be. So you're going to put in this first line. It's able to obtain a written, and you put what type of loan you're going to get. Most we'll put in conventional. If you identify the lender, that means your financing commitment has to come from that lender. So you put conventional, Chase Mortgage or something. It's best not to put the lender in. So that means if you decide you don't like the service you're getting or you don't like the product you're getting, that you can switch to a different lender within this time frame. You're going to get a first mortgage loan, not a secondary, but a first mortgage loan commitment as described below within how many days after writing this offer. Generally, I think right now, and correct me, Steph, because I'm not writing offers right now, it's probably 35 days.
Yep.
Is that about
No.
right?
Yep. Joni, I don't know if you can hear me.
You're muted. I can't hear you.
I think there's something going on with your, yeah. Well, anyway, 30 days, 30 to 45 days, everybody.
Wait. Anyway. Okay, talk. I don't think my AirPods were connected.
Can you hear me now?
I still can't hear you.
Oh, I think it's, try turning up.
Oh, now I can hear you. Okay.
All right, cool. Yes, 30 to 45 days, you guys.
Okay.
Yeah, it's still what's typical.
So what you're putting in here, and I've had to correct some newer agents on this line. What you're putting in this line 251 is the financing selected shall be in the amount of not less than. You're putting in the loan amount there, not, it's going to be whatever your loan amount is minus your down payment. So what your loan amount is here for a term of not less than, generally it's 30 years, amortized over 30 years. Initial monthly payments of principal and interest, don't include taxes or insurance, just principal and interest, shall not exceed. So with your mortgage calculator, you put in the loan amount, and this is the amount minus your down payment. So you do the loan amount and the actual rate that you're going to get from the lender, which you put down here, and it will give you the actual monthly payment, including principal and interest, but not taxes and insurance. So that will give you the monthly account. Buyer acknowledges the lender's required monthly payments may also include. They may do that, but that's not what you're putting in here. This next line shall not include a prepayment premium. Buyer agrees to pay discount points. There really are no discount points at this time. Money's available. So mostly put as 0 in there if you leave a blank at 0. Buyers using multiple loan sources, obtaining a construction loan described in this. If they're doing that in or in an addendum attached, that means you want to be specific about what type of loan you're going to get. Could be a construction loan if you're building a home, but you want to make sure that you are describing at lines 543, 551, or an addendum what type. Buyer agrees to pay all customary loan and closing costs, wire fees, loan origination costs. So these are extra costs the lender is going to charge you, the buyer, to get the loan. And then provide evidence of an application promptly upon the request of the seller. Seller doesn't want to know that you are out there shopping for a good loan. As soon as you're writing the offer, you are to promptly apply for a mortgage loan, and this is really important. Seller agrees to allow the lender's appraiser access to the property. That's very important too, because the lender will want to send an appraiser into the property and know that he has access. This sometimes, depending on, say they don't like the price we put in our offer, and it's counted back and forth and we come up with a new price, it just says, if the purchase price under this offer is modified, any financed amount otherwise provided shall be adjusted to the same percentage of the purchase price. So say you were putting in an offer at $350, but the seller wanted $375 as he had it listed, and you finally agree to $375. What you have in here, based on how much down payment you're going to put, will automatically adjust to that price. So you don't have to do an amendment to your financing when you settle on a final price. It will adjust. And now down here, check and complete applicable financing provision. Are you doing a fixed rate, which probably 99% of us are doing now? You'll mark here and you put down the rate shall not exceed. Say the rates right now are at 2.9, I don't know what they are. You might want to put a little cushion on that, maybe put 3.3%, just because during the process of this loan, if the rate does go up, your financing contingency still includes that. The seller's not going to want the lowest rate you can find and put in there, because if it goes up, then you can't get your financing and it's an escape on the contract. So give it a little cushion to make the seller feel better.
I always like to explain it to the buyer that it's not the number that they're going to necessarily lock in at, but the number that if it were to jump up to that rate, they would still feel comfortable moving forward. Right.
As I said, you're going to want to appease the seller. You're saying to the seller, maybe I'm not giving you a full list price, but here's a very strong financing commitment. And obviously a strong financing commitment is going to be right here on what your loan amount is. So say you settled on the price of $370 and you're willing to put down 15% or 20% or whatever, it's going to be 20% off of $370 here is going to be your loan amount. So the seller will be able to see if you're coming in strong with a high down payment. That gives him more comfort as well, is that you're really going to get your financing. If you have like a 5% down payment, that makes the seller a little more uneasy, and he'll be able to calculate it based on what the purchase price is, based on what your loan amount is. And he can figure out what your down payment is. So the satisfaction of the loan commitment, of the financing commitment, if buyer qualifies for the loan described in this offer, and he's got to get that in right here on this many days, within so many days, and we said like 35, 40 days, maybe you get the loan commitment. Buyer agrees to deliver to seller a copy of the written loan commitment. And this is important to remember. This contingency shall be satisfied if, after buyer's review, buyer delivers to seller a written loan commitment that is signed by the buyer or accompanied by a buyer's written direction for delivery. Got to make sure that the buyer has seen this loan commitment and agrees to send it to the seller through the listing agent. The problem with that, and that's the caution right here, a loan commitment can have some conditions on it, like you need to sell your house first before you get this money. The buyer must yet satisfy to obligate a lender to provide the loan. Buyer understands delivery of the loan commitment removes the financing commitment. So if you deliver it and it has some important conditions on it and it's delivered to the seller, you better get those conditions satisfied, because as far as the seller's concerned, you have satisfied your financing commitment contingency. So I hope you make that clear. do not deliver a loan commitment unless the buyer agrees to it and is signed off on it. And I'm just going to finish up with the last of this part of the financing contingency, and then we'll take part 2 next Monday and finish off the other contingencies and the other important parts of this offer to purchase. But right now, the seller has termination. So the delivered loan commitment, as I said, may contain conditions. And the buyer doesn't want to send that loan commitment to the seller unless he's okay with that or those conditions can be met. So he goes over these 35 days or 40 days that we've put up here in the offer. The seller has the unilateral right to let the buyer float and get that loan commitment in. He doesn't have another possibility buyer in the wings. He really likes this buyer, but the lender is saying it may be a few more days before we get the loan commitment to you. The buyer can wait and unilaterally, or if he doesn't get it on that date, say he does have another buyer in the wings, he can terminate that offer like that with no reasons or rights other than the loan commitment is a day late. So seller may terminate this offer if seller delivers a written notice of termination to the buyer. So he has to send a notice saying he's terminating the offer prior to the seller's actual receipt. So financing commitment unavailable. If financing commitment is not available on the terms of this offer and buyer has not delivered an acceptable loan commitment, buyer shall promptly deliver written notice of seller of the letter from the lender saying we can't give you the loan. So it has to be a lender's rejection letter, plus it has to be a notice saying they can't meet the financing commitment on time, and a camera, because at that point this offer is null and void. The seller was not able to meet his financing contingency, so that allows him an escape from the contract. Seller financing. If you want to give the seller the right to come in and finance it himself, which I've seen happen, you mark this box. If you don't want that seller to have the right to do that, you put NA there. Okay, most people don't want the seller to chip in at this point. So I'm going to end today's date here because it's a little after 2 o'clock. And any questions that you have on this first part that we did, we'll finish up the next part next Monday from 1 to 2, and encourage other agents to hop onto this if you find this helpful. All right. Have a good day. Thank you very much for attending.
And just to close that out too, I just want to let you guys know that I've written down who's attended the training, and I'll send those links to the inspection contingency training that I referenced in the chat. And then that training on the right to cure that Joni and I did sometime this year. So,
Right.
But yeah, it's good to go have a deeper dive into the inspection for sure, and the concept of right to cure. As Joni gets into this next week, right to cure is attached to the appraisal contingency. So it's just really good to get a good grasp on that concept. So I'll send that off to you guys in an email after this. And thank you, Joni.
Thank you. Thank you, everybody, for coming on.
All right. We'll see you guys next week.
All right. Bye-bye.
Bye.